Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 79. In this podcast we're going to be discussing three different cases. The first is an EAT decision considering whether an associative victimisation claim can be brought under the Equality Act. And this case follows the recent trend of claims that seem to be developing this concept of associative discrimination. Second case continues the theme of expanding the scope for people to claim protection under the discrimination laws because it looks at whether a limited company can bring a claim of direct discrimination under the Equality Act. The third, final case, it's an ECJ case which provides useful guidance on the EU jurisdiction regime and the application of EU jurisdictional rules in respect to an individual who is both an employee and a director. As always, this podcast can be found through Mayor Brown's website, on iTunes, and via YouTube and Twitter. If you follow me on my Twitter account, Nicholas Robertson, at Nicholas ROBER, and then the numbers 1 and 1, this will also give you links to all of the cases that we discuss in the podcasts. I should also say at the beginning, thank you very much indeed for the feedback on the last podcast. A special shout out to Julia and Vicky, each whom got in touch to say they'd noticed my absence while I was away, which was very nice of them. So thank you. So, first case is Thompson and London Central Bus Company Limited. This is an EAT decision looking at a tribunal's decision to strike out a claim of victimisation by association. And it follows a number of recent cases that have potentially widened the scope of discrimination law. And this shows an ongoing shift in the boundaries. As a quick summary, under the Equality Act, victimisation occurs where person A subjects person B to a detriment because either B has done a protected act or A believes that B has done or may do a protected act. And until the recent case, the Bulgarian electricity case, which I discussed, Shares Razpredele Bulgaria, or words to that effect, look up Bulgarian electricity case on the internet, and I discussed this in podcast 77. It was thought that associative discrimination was limited in scope to claims of direct discrimination and harassment. But the Bulgarian case demonstrated that the concept of associative discrimination may not be limited to direct discrimination and harassment, but could in fact include indirect discrimination as well. And this case in turn also shifts the scope of discrimination law and would mark a change to the tribunal's approach in such cases. Facts were very simple. Mr. Thompson worked as a bus driver for the London Central Bus Company, and he was dismissed for having given his high-visibility jacket to another employee. Mr. Thompson was already subject to a final written warning and was consequently dismissed as a result of the disciplinary offence. Although he successfully appealed internally against the dismissal decision and was reinstated, he claimed the original decision to dismiss was an act of victimisation, and the grounds for his victimisation claim were not that he had done a protected act himself, but rather that he was subjected to a detriment as a result of a protected act done by others with whom he was associated. He claimed he told the manager about a conversation between two other employees in which those two other employees had accused the company of having breached the Equality Act. Mr. Thompson argued that, following this conversation, the manager associated him with those employees and their protected act, and he alleged that this was the reason for the disciplinary action against him in reality. I should make it clear the case is still going on. We've had preliminary hearings, but the actual facts of the case are undetermined. The key question as to whether an associative victimisation claim can be brought under the Equality Act was considered at a preliminary hearing of the Employment Tribunal, and the Employment Tribunal concluded that the Equality Act had to be read widely as protecting employees against such associative victimisation. It held the Equality Act should be construed broadly to cover situations where the reason for the detriment suffered by an individual is the protected act of another. Now, this particular point was not appealed to the EAT, so we only have an Employment Tribunal decision on this. But the Employment Tribunal decided that there needed to be a further preliminary hearing to consider whether the necessary causal connection between the protected acts of the other employees and the alleged detriment suffered by Mr. Thompson had been satisfied on the facts, because the tribunal assumed there needed to be a particular level of association. The tribunal concluded that the association between Mr. Thompson and the individual's conversation was, quote, so tenuous, unquote, that Mr. Thompson could not be afforded the scope of the protection of the associated discrimination rules. Mr. Thompson was only, quote, loosely, unquote, connected to the other employees by virtue of his trade union membership. The tribunal held that, quote, awareness of the contents of a conversation subsequently repeated cannot without more amount to association of the purpose of the concept of associative victimisation, unquote. The tribunal therefore struck out Mr. Thompson's claim on the ground that it had no reasonable prospect of success, and Mr. Thompson appealed to the AT. Unfortunately, the AT's decision does not deal with the point of law as to whether the Equality Act should be read widely so as to allow a victimisation claim based on the acts of third parties. That part of the decision, the first preliminary hearing of the Employment Tribunal, was not appealed by the losing employer. However, interestingly, the EAT disagreed with the Tribunal in respect to the decision to strike the claim out. The EAT concluded that the issue is not whether there is a particular kind of relationship or degree of association in existence between the parties, but instead whether the, quote, protected act of a third party was part of the reason for the treatment of the employee, unquote. The EAT held that this would be a question of fact for an employment tribunal, and such a decision should not be made without hearing the evidence, all of it. The AT concluded it could be entirely possible to conceive of a situation where an employee's membership of a trade union, which had protested about certain protected acts, may cause an employer to treat the employees generally in a detrimental way. So the AT allowed the appeal. Well, overall, this case has the potential to amount to a significant shift in the law, doing away with the previous understanding that claims based on association were limited to direct discrimination and harassment. And claims based on victimisation can only be brought by an individual who had done the protected act himself. However, we should be cautious in treating this decision as the final word on the matter because it is only an employment tribunal decision, and I think it's likely that there will be a challenge at some point. That being said, following the decision in the Bulgarian electricity case, it seems that an interesting new principle is developing the treatment of associative discrimination claims by the courts. Now, it would indeed be helpful to have a higher authority on this point. The drafting of the Equality Act was generally held to preclude associative discrimination complaints. Although the direct and harassment provisions of the Act are more widely drafted, the wording of the victimisation provisions is far narrower, and on a natural reading of the legislation, requires the claimant alleging discrimination to perform the protected act. Well, this case and the Bulgarian case clearly represent a shift in approach and demonstrate the tribunal is prepared to take a constructive, shall we say, interpretation approach. Equally, UK victimisation law can now be extended to cover associative victimisation, and if that's the case, then that will obviously widen the pool of claimants who are able to claim. I don't think anyone is suggesting these claims will become commonplace, but it's fairly easy to identify situations where such claims might arise. For example, if a workforce has a number of equal pay claims launched by its members which are supported by the trade union, and that causes the employer to have to spend significant time and devote significant resources to fighting litigation, there could easily be an underlying possibility the employer might subsequently close down that site and relocate business to a different, better behaved site, or might rationalise that particular site out of existence. Well, based on this case, employees will be able to say that because they are working at the site in question, they are associated in effect with equal pay claims and therefore being victimised when the site is closed down. It's going to be necessary in those circumstances for the employer to prove its version of events and that the decision-making had a different motivation. You don't need a crystal ball to see that claimant lawyers might be quite interested in getting a claim like this off the ground if they could cover all of the employees working at a particular site. It's going to be necessary to demonstrate there is actually linkage between the decision in my hypothetical example to rationalise the site away and the original equal pay claims. And this will put pressure on the employer to make sure that its subsequent adverse decision in relation to that site can withstand detailed scrutiny. It's also going to put particular pressure on the employer to make sure management don't send unwise emails to each other expressing frustration at the equal pay cases. And the other point to mention is I think there's an interesting overlap between whistleblowing and this sort of associative victimisation complaint. I think if the fact pattern here had been relayed to me before the decision, my immediate reaction would be the individual would be trying to bring a claim under the whistleblowing legislation. And this, of course, does require certain preconditions to be met, including, for example, that the disclosure is believed to be in the public interest. Those safeguards would disappear if the concept of associative discrimination is open to an employee. Now, obviously, the underlying protected disclosure will still have to be linked to a matter of discrimination in order to trigger the associative victimisation protection. But I think claimants may look to rely on associative victimisation because it'll be easier to show and sidestep some of the preconditions for protection under the Public Interest Disclosure Act. So I think employers are going to need to be alert to the possibility of these types of claims being brought. So that's the case of Thompson and the London Central Bus Company Limited. Next up, EAD Solicitors, LLP and others, and Abrams. Now, this case looks at whether it's possible for a limited company, which is a member of an LLP, to bring a claim against the LLP for direct discrimination under the Equality Act. In this case, the limited company that was claiming it was claiming it was directly discriminated against and had suffered detrimental treatment because of its association with its sole director and the age of that sole director. Now, it's worth mentioning the key legislation. Let's start with that. First, Section 45 brackets 2 brackets of the Equality Act states, amongst other things, that an LLP must not discriminate against a member of that LLP by subjecting the member to any detriment. This clause brings members of LLPs within the scope of the Equality Act protection. Secondly, there's legislation that states that LLP members can include individuals or corporate bodies. So it's entirely possible, and indeed not uncommon, for a limited company to be a member of an LLP. Finally, Section 13 of the Equality Act states that a person discriminates against another person if, because of a protected characteristic, that first person treats them less favourably than they would treat others. The facts in this were that Mr. Abrams was a member of EAD Solicitors, LLP, with Limited Liability Partnership. It was a term of the LLP agreement that a member would retire on his 62nd birthday. As he neared retirement, Mr. Abrams set up his own limited company. He was the sole director of that company. He subsequently withdrew from his membership of the LLP, and the company, for which he was the sole director, became a member of the LLP in his place. So he's out and his company is in. That company continued to provide services to the LLP, but Mr. Abrams was not technically obliged to perform those services himself. The LLP only had a contract with the company, and there was no continuing contractual relationship between Mr. Abrams and the LLP. When Mr. Abrams turned 62, which is the compulsory retirement age, the LLP ceased paying the company its share profits and objected to the company offering Mr. Abrams services to it. As a result, the company brought a claim for direct discrimination against the LLP, claiming that it had suffered a detriment by reason of being associated with Mr. Abrams, who had the protected characteristics of age, his particular age. Before the case was heard by the tribunal, as a preliminary issue, the tribunal and then the EAT were asked to consider, in principle, whether a limited company was entitled to bring a claim under the Equality Act. As such, we have the EAT's preliminary ruling at this stage, and again, no decision has been made on the actual facts. To summarise briefly the parties' positions, the company argued that discrimination under the Equality Act could include a corporate body, and therefore in principle it could bring a claim for direct discrimination, but the LLP argued that the whole thrust of the anti-discrimination provisions in the Equality Act were directed towards the protection of individuals with protected characteristics, and therefore the limited company could not, as a matter of principle, they said, bring its claim. Well, the EAT decided that the word, quote, person, unquote, in Section 13 of the Equality Act could mean both a natural person or a legal person. Therefore, the company could, in principle, bring a claim for direct discrimination. It held that the Equality Act does not focus on individuals, but rather focuses on protected characteristics, and it's wholly possible to identify discrimination as being detrimental treatment caused by a protected characteristic, without reference to that individual claimant having that characteristic. So, the detrimental treatment itself can be suffered by any person, whether that person is a natural individual or a legal entity, such as a company. There's no requirement the detriment has to be suffered by the individual himself. So we can see evidence of this in the trend of recent cases in relation to associative discrimination, where the detriment is not suffered by the person who holds the protected characteristic, age or health, whatever, but it's the detriment is suffered by a person associated with a person with a protected characteristic. So, dread phrase I know, but this is a really interesting case as it looks at the novel issue of a limited company bringing a claim for direct discrimination under the Equality Act. However, whilst this case has received a lot of attention from the media, it is rather more limited in the employment context than it first appears. Start at the beginning. The limited company was only able to fall within the scope of the Equality Act by virtue of being a member of an LLP, which is protected under Section 45 of the Equality Act. If the limited company was just providing consultancy services to another limited company, i.e. not an LLP, then it wouldn't necessarily be able to bring a claim under the Equality Act, as it would not fall within the terms of Section 45. And I mean, as a general statement, if you're looking to bring a claim under the Equality Act, you have to find the relevant chapter and then the provision which brings you within its scope. Employees within Section 39, contract workers Section 41, trade organisations Section 57, and so on. Secondly, in some cases already, you wouldn't need the service company to bring such a claim, as the individuals themselves will be able to bring a claim in their own right by virtue of being a contract worker within the terms of Section 41. So in other words, the law already addresses a situation where the individual is able to claim the protection of the discrimination laws, even though he or she doesn't have a contract directly with the alleged discriminator. If the individual can bring the claim himself, it seems to me that there's very little to be gained by having the company join the proceedings as a claimant. And so, again, my reaction is that at the moment, the primary time when it might be useful to bring this sort of claim, this limited company claim, is where the individual doesn't qualify as a contract worker for the purpose of Section 41. So, for example, if he's not employed by his service company, then he wouldn't be a contract worker. That being said, in an age where we see more consultancy arrangements of this type, where there will be often one contract worker who is the director who sets up the company to provide his own services, no one else's, it's entirely possible that corporate discrimination claims of this type might become more frequent. It is also an interesting question whether you could put indemnities into the arrangement, in this case between the LLP and the service company, so the service company indemnified the LLP if any claims of discrimination arose. I certainly have seen those. Indeed, I may have drafted them. But if the service company itself has the right to bring claims for discrimination, then asking it to indemnify the end user against its own claims would probably amount to unlawful contracting out of its statutory rights. One additional point is that I don't think it's necessary to limit the rationale in this decision to service companies or limited companies with only one employee. It may be easier to show that there is the potential for the necessary association where there's only one employee, if that employee has particular protected characteristics. But if it's possible to show that a company is predominantly associated with, individuals from a particular ethnic background or particular gender, then the logic of this decision would enable the company to claim for discrimination if the company is treated adversely for reasons connected with those protected characteristics. Ultimately, I think the case has a significant impact outside of the employment law context, as the EAT's general comment that the word person in the Equality Act can mean legal entity is very sweeping. It could have far greater implications in the context of discrimination laws surrounding the provision of goods and services. For example, it's possible following this case that a legal entity, whether a company, LLP, charity or other corporate, could now bring a claim in the context of providing goods and services based on the protected characteristics of the individuals associated with that company. Customers, employees, directors, members, whatever. I think it's very questionable whether Parliament could have been said to have intended this. In fact, my personal bet is that at the time of drafting the Equality Act, no one even turned their mind to the possibility. Anyway, I do think it is a very important case, and it is only a preliminary issue, so it's bound to make the press again when it works its way back to a full decision if the case isn't settled. And I think I would be very surprised if we don't see other cases coming through exploring exactly in what circumstances a limited company can bring a discrimination claim. So, third and final case, Holterman, Furho, etc., and Spies von Bullesheim. Apologies to all those who know how the name actually should be pronounced. Well, this is an ECJ decision which looks at EU jurisdictional rules which apply where the employee in question is being sued in his capacity as both employee and director. And the case also provides a really useful overview of the EU jurisdictional regime. As we explained all those podcasts ago, back in podcast 76, which considered the case of PETA and EMC Corporation, an employee is protected under EU law and the Brussels recast regulation in relation to where a claim can be brought under the terms of their contract of employment, as they are the weaker party to the employment contract. And for a better understanding of the PETA case and the EU jurisdiction provisions that are in play, please do feel free to go back and listen again to podcast 76, where we set it out in a bit more detail. As a brief reminder, though, the general rule under EU law is that a person has a right to be sued in his or her country of domicile. However, there are certain jurisdictional variations under the 2001 regulations and the recast regulation, which act as an exception to this general rule. In contractual matters, for example, a person domiciled in a member state can be sued in the courts of the member state where the contractual obligation was performed or the services under the contract were provided, unless otherwise agreed. In tortious matters, a person domiciled in a member state may be sued in the courts of the member state where the harmful event occurred. But in the case of individual contracts of employment, the employee can sue the employer in the courts where the employee is domiciled or where the employee habitually works. However, an employer may only sue an employee in the member state where the employee is actually domiciled. In this case, Mr. Spies von Bullesheim, who I'm going to call Mr. S from now on, was an employee of Holtermann, which had a Dutch holding company, but he was domiciled in Germany. He was also a director of both Holtermann and its 3 German subsidiaries. Holtermann and the German subsidiaries attempted to sue Mr. S in Holland for serious misconduct in the performance of his duties, as well as on the grounds of dishonesty and recklessness in the performance of his contract, which, it alleged, amount to breaches of the Dutch Civil Code. Mr. S argued that the Dutch courts did not have jurisdiction to hear the claims, relied on the exception under the Brussels regulation relating to individual contracts of employment, and the need to sue where the employee is domiciled. He argued that EU law protected his right to only be sued in the member state courts where he was domiciled. Well, the case went through the Dutch courts until proceedings were stayed and questions referred to the ECJ on various jurisdictional matters. And again, my libel lawyers would like me to point out that this case is continuing, and so these allegations have not yet been definitively determined. Well, the main question the ECJ was asked to consider was whether an employee who is also a director can rely on the employment exception in the Brussels regulation, so they can insist on only being sued in the country in which they are domiciled. The challenge was that the claims against him were partly in relation to his employment, but also partly in relation to his duties as a director. And the ECJ concluded that Mr. S, even in his dual capacity as an employee and director, was able to rely on the employment exception in the Brussels regulation and insist on only being sued in his country of domicile, Germany, and not Netherlands, which is where he had worked. And the ECJ held that despite Mr. S's seniority and position as a director, if he was an employee, he remained the weaker party to the contract of employment and, as such, should be afforded the protection of the Brussels regulations. There are some key points to emerge from the ECJ's judgment that mainly accord with the approach taken in Petter, and the ECJ held that the essential feature of an employment relationship is that for a certain period of time, one person performs services for and under the direction of another, in return for which he receives remuneration. Unquote. The ECJ stated that an independent EU-wide interpretation must be given to the concept of an individual contract of employment to ensure effective application of the Brussels regulation. In other words, it is not for the national courts to apply the national definition of employee to this question. Now, the reason I mention this is that the ECJ definition of employment looks at common features of employment and talks about the need for there to be a lasting bond, ensuring the worker is subsumed to some extent within the organisational framework of the business, and it, quote, presupposes a relationship of subordination, unquote. However, the court note that Mr. S was very senior, although he wasn't the major shareholder in this company, and say that he was able to influence the company's administrative body, of which he was the manager, to a greater than negligible extent, quote, it would be appropriate to conclude there is no relationship of subordination for the purpose of the court's case law and the definition of worker, unquote. I think that probably reflects the practice of some European member states to deny employment status to very senior employees in a way which English employment law has not done. There might be a neat question as to whether someone who is outside the scope of the European Court's definition of employee is entitled to any more favourable definition of employee in national law, or whether this is precluded by the need for European uniformity. That's one to wait for another day. However, if you find yourself looking at this, it is important to look at what the court says about the definition of employee to work out whether the individual in your case is an employee or not. As with Petter, the ECJ made clear that for the special protections available to employees to be engaged, the claim that is the subject matter of the proceedings must derive or relate in some way to the contract of employment. But, as we saw in Petter, this need not necessarily mean from the physical contract of employment itself, and the courts have shown they are willing to take a wide view of the scope of this section and what is classified as being sufficiently connected to a contract of employment. Although the ECJ acknowledged that the factual analysis is a matter for the national courts to determine, it's clear from the judgment the existence of a claim under the employment contract trumps all other contractual or statutory claims sitting alongside it, and means that the special rules relating to individual contracts of employment prevail, rather than special rules related to contracts, which would have allowed him to be sued in the Netherlands, because that's where he apparently carried out his work. So on that basis, the company wanted to establish misconduct by him in relation to his duties as a director and as a manager, but he was an employee, let's assume, within the definition of the European Court's understanding of the term. And if that was right, factually, still to be determined, he could only be sued in the courts of Germany, where he was domiciled. It didn't matter whether the employee is a director, as was the case here, or whether there was an exclusive jurisdiction clause in play, as there was in PETA. The employee could only be sued in the courts of the member state in which they are domiciled. Well, this case acts as a really useful summary of the Brussels regulations and follows an ongoing trend seen in recent EU case law, where employers with a global workforce need to be alive to the issues of jurisdiction, and that subject to where the employee is domiciled, the employer may not be able to issue proceedings against the employee in its own country of origin, often the UK in our case. Helpfully, the court did go on to talk about the rules which would apply if the national court found that Mr. S was not an employee. Given what I said about the court's definition of employee, this point may come up more often than you might think. Equally, presumably, there are still circumstances where the individual's status is as an employee is utterly irrelevant to the employer's claim, in which case I don't think the employment status protection would apply. I don't think this case or any other case goes as far as saying that merely because you're an employee, then in, say, a shareholder dispute, where you've got an individual who is a shareholder and an employee, the existence of the employment contract means the individual has to be sued in his country of domicile. In brief, I think here the court decided that if the individual was not an employee and the matter related to the performance of a contract, then the individual could be sued in the country in which the duties were performed, or where the individual was domiciled. If the claim was a tort claim, then the individual could be sued in the country where the damage was done. However, 2 points of caution in his last statement. First, the court said that if it was a tort claim and was also a breach of contract claim, then the contract rules would apply. Secondly, the court said that the ability to bring a claim in the country where the damage occurred did not allow the company, if it was suing the individual for a tort claim, to bring a claim in any country where damage had occurred. I think we're going to see quite a lot more thought being put by employers into matters such as confidentiality clauses, notice provisions, post-termination restrictive covenants, in an increasingly globally mobile workforce. It's always been a surprise to me, to be honest, that where you have a global market, we don't really see signs of employees looking to base themselves in particularly favourable jurisdictions when they leave employment, i.e. where the national rules preclude the application of the restrictive covenants contained in the employee's contract of employment with the old employer. Surely this is something that will come, and then employers and the lawyers are going to look forward to work out how to meet that particular challenge. So that's the case of Holterman and Spies von Bullesheim. So thank you very much indeed for listening. That's been a slightly longer podcast than normal. I hope it was useful. It remains for me to say, of course, that as usual in the making of this podcast, no employees were harmed or mistreated in any way. And to say, I hope you'll join me 2 weeks' time for podcast number 80. How we're getting through them. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.